James Gyakye Quayson's eligibility as a member of parliament has been in contention since he won the 2020 December parliamentary elections. The matter has gone to the High Court, the Court of Appeal. There's an aspect of it that is also at the High Court in terms of a criminal matter. But some finality has been brought to it as the Supreme Court has by unanimous decision ruled that he was not eligible to contest the 2020 polls. The court, presided over by Justice Jones Doche, also held that the Electoral Commission acted unconstitutionally when it allowed him to contest the parliamentary polls without proof of renunciation of his Canadian citizenship. The court then issued an order asking Parliament to expunge James Gyakye Quayson's name from its records as a member of Parliament. And so this is the decision of the Supreme Court, and lawyers for Michael Ankuman Infan, led by Frank Davis, are excited by this decision.
We have to protect the sanctity of the Constitution, and we are gratified that the law lords, all the 7 of them, have agreed unanimously with the position we have held all along, that at all times material, James Gyakye Quayson was not qualified under the dictates of the Constitution of the Republic to have contested as a member of Parliament for the Assin North constituency. It's been a long road. We can all attest to the number of times we have paraded the court premises. But today, finally, the judgment has been handed, and we have a clear indication as to what the provision on dual citizenship is in respect of a contest for member of Parliament.
I mean, what do you expect to happen practically going forward? The court interestingly gave an order that his name should be expunged from the records of Parliament.
Of course, but that is a necessary consequence of the reliefs that we sought in the Supreme Court. If he wasn't qualified to have contested as a member of Parliament, of course, the necessary inference is that whatever happened was null and void and of no legal effect whatsoever. So Parliament cannot still keep his name on their books. It's a necessary consequence, but of course the order has to be drawn and served on the Speaker, and his name will have to be expunged. That is the constitutional injunction on the EC. So my client is not looking forward to anything. The EC will have to comply. Insofar as that seat now remains vacant, the EC has to conduct elections in that constituency. So it is not for my client to be looking forward to. It is for the EC to comply with the orders of the Supreme Court. And the constitutional injunction is that if a seat is vacant, you organize fresh elections.
And so the lawyers expect the orders of the court to be drawn up and served on Parliament, and that the Speaker will declare the seat vacant, after which they expect the Electoral Commission to proceed to organize primaries. For joining us from the Supreme Court, my name is Joseph Akable.